Constitution. It's the first I've heard of that being advanced as an argument. Indeed, the standing of these appellants to raise any of the issues regarding SAPA, I believe, is highly questionable because they were raised by other petitioners who did not appeal, with the one exception of the RIS, the Regulatory Impact Statement. That was the only suggestion in the petition of these appellants that there was any impropriety at all asserted with regard to SAPA. In effect, they learned about the other arguments, which they now advance so vigorously, when they read them in the petition and the briefs of the other parties who elected not to appeal.
Isn't the fact that most of these regulations were in use as TOGs assigned as a reason for not having to comply strictly with the notice requirement of SAPA?
No, sir. This is what happened, actually, if I could explain that, because I think it's key to the understanding of the case. The TOGs were in force, as were the 8 original regulations. And, of course, the appellants all had permits, so they knew very well what substances they were discharging. There's no question about that. The state, in its original notice of hearing, which happened back in September, when it supplied the draft EIS and the remaining documents, told the appellants, and indeed everybody else, precisely what the methodologies were to be. They had the methodologies, in other words, the scientific explanations for how these numbers were going to be arrived at. They knew themselves what they were discharging, and they also knew that they were subject to the TOGs. The TOGs were not enacted or enforced in a vacuum. There was a work group which included those industrial groups as well as environmental groups and local governments and others, so that none of this was taking place in a vacuum. Everybody was aware of the TOGs. Having the methodologies, the appellants at that point were perfectly capable of figuring out what the standards were going to be for the substances which were listed in their own permits and which they very well knew they were discharging. Whether or not the state had to go further, which is a question we don't have to reach here because they did in fact go further, the state elected to supply the fact sheets. And contrary to what was suggested earlier, every single standard that was ultimately adopted was adopted on the basis of a fact sheet that the appellants had for at least 30 days. They got some of them in October, well in advance of the hearings. They got others in November. They got some later on, but then, again, contrary to what was suggested, there was a 2.5-month postponement from November 30th to January and then to February 15th given by the commissioner in order to enable people to respond. And there's nothing magic about these hearings, incidentally. These were not evidentiary hearings where one could cross-examine the state's experts and say, where did you get these numbers from and why don't they make sense? Those weren't those kind of hearings. They were, of course, legislative-type hearings, and the record was kept open so that the appellants and anybody else who wished to were perfectly free to comment for a long period of time, 2.5 months from November to mid-February, 85, after the close of the hearings. They couldn't do it orally. They could do it in writing. And, of course, since we're talking about highly technical scientific matter, and it was not an evidentiary hearing where you could cross-examine anyone, there wasn't anything much to be gained by getting up and saying these things orally about how many parts per million the number ought to be. So that, in fact, they had far more than SAPA requires. SAPA only requires opportunity to comment, and they had more than that. And, in fact, as noted, there was a fact sheet delivered at least 30 days in advance of the close of the comment period for every single one of these standards. In fact, the department went so far as to not adopt the standard where there wasn't any fact sheet or where the numbers in the fact sheet differed by more than 20% from the numbers that were previously in the TOGs. So it's unbelievable that appellants could now argue that they were seriously prejudiced by this in any way. The fact sheets, contrary to what was suggested also, didn't supply the scientific basis, as was urged. They only supplied the list of the actual chemicals and the application of the methodologies, which the appellants already had because they were supplied initially from day one when the draft environmental impact statement was supplied, so they had that. They could couple that with what they knew from their own permits and their own knowledge they were discharging, and one might say that that's all they needed, although in fact one doesn't have to say that because they were supplied far more than that. As noted, they were supplied with the fact sheets, and they, in fact, the department only adopted a standard where there was a fact sheet supplied and where the numbers in the fact sheet didn't differ significantly from the numbers that were already in the TOGs. Now, we've heard a great deal about the regulatory impact statement. The regulatory impact statement dealt, as noted in our brief, with those substances where there was a significantly greater economic impact because the numbers, in fact, were substantially increased from the numbers that had previously been in the TOGS plus the 8 original substances to have been regulated in the actual standards. For the rest, there wasn't any economic impact, or at least the department, under the normal rules of deference, and by the way, I can't imagine why the normal rules of deference to administrative agencies don't apply here. The cases are legion. They're cited in the briefs of the state and the intervener, that in prescribing its own calendar, in making these kinds of determinations, administrative agencies, of course, are afforded the same kind of deference that they're afforded with regard to the actual numbers themselves. So we regard the order of the appellate division, which unanimously, affirming special term, upheld these very important regulations regulating toxic chemicals, which have now supplanted the old bacterial sewage as the main water pollution problem in the state, as deserving of affirmance, and the order of the appellate division should be affirmed.
Thank you, Mr. Weinberg.
Thank you.
Mr. Keehan?
Thank you, Your Honor. Pursuant to the court's letter, I'm going to address seeker, whereas Mr. Weinberg addressed SAPA. ILC claims that DEC failed to comply with seeker for two reasons. It says, one, that they failed to address the impacts or the damage which they speculate would result as a result of additional treatment which would be required by those standards which would be lower than the TOGS. They also say that DEC failed to address what they call cumulative impacts, which would arise because DEC was simultaneously starting a program to reclassify the streams in the 17 major water basins of the state. Now, the difference between these two actions are, one, the standards set forth what amounts of pollutants may go into the ambient waters. The classifications, they state what the best uses of the water will be, and then the waters are classified as either an A water, a B water, or a C water, or a D water, each having different requirements. Now, since DEC found that each methodology and each standard would lower and decrease the discharge of toxics into the waters of the state, it concluded reasonably that the action would not have an environmental impact, rather the impacts would be beneficial and not adverse to the environment. Now, seeker requires that under an EIS, consideration should be given only to those impacts which are significant and can be reasonably expected. Our courts have consistently held that not every impact must be identified or addressed. In considering the insufficiency of an EIS, a court should only consider whether it was made in good faith and whether the statement of findings addressed the environmental issues. When a party challenges an EIS, they have the heavy burden of establishing that the omitted issue or impact was necessary and important to the result. Now, as to ILC's first contention that the EIS failed to address impacts which result from additional treatment should not even be considered by this court because it was not raised by anyone in response to the draft environmental impact statement. And as this court held in Jackson v. Urban Development, that when a party raises an issue for the first time in a court proceeding, very little attention should be paid or very little weight should be given to their arguments in that regard. Now, contrary to ILC's statement in their brief, they say this issue was raised many, many times, and they make a citation to the record, and that citation is not to the administrative hearing. It's to a affidavit which was prepared a year later, not by ILC, but by the National Association of Waste People, who said that this should have been raised, but they were saying this in the court proceeding. DEC didn't have this knowledge or this claim before them when they were making their FEIS. As the courts below held, in any event, these are speculative and they go beyond the purposes of seeker. In fact, this very court in the United Petroleum v. Williams held that a similar argument had no merit, In fact, in that case, the decision of the appellate division stated, indeed, the intent of the regulation is to improve the environment, not harm it. Now, those words were adopted by this court, and we have the same situation here. When you consider reasonable probabilities under seeker, DEC should not be required to assume that its laws relating to solid waste and air pollution are insufficient to adequately regulate any additional forms of pollution which may result as a result of these regulations. DEC, or ILC, is correct in stating that long-term impacts should be considered, but they must be significant and they must be reasonable. Now, it's pure conjecture for them to say that as a result of the standards, a polluter is going to discharge his waste in a certain way, and that as a result, and it is even more presumptuous of them to say that their discharges are going to result in environmental harm. That's all sheer speculation. The maker of an EIS should not be faulted for putting in a final EIS every conceivable theory or prediction conjured up by an opponent to the proposal, particularly when it is made after the FEIS has been completed and they have considered all of the comments which have been addressed during the seeker proceeding. Now, in point 2 of their brief, they contend that DEC failed to address cumulative effects resulting from DEC's separate proposal to reclassify the water basins in the water bodies and major drainage basins. Again, they're dealing in speculation. Its position in this regard is based upon two premises, and neither is valid. Its first faulty premise is ILC's contention that the reclassification program and this proposal relating to water quality standards are interrelated. They state no facts to suggest that the reclassification program is connected to, dependent upon, or was undertaken as a result of this proposal. They base their conclusion upon a misrepresentation of the facts. They cite 2 portions of the brief saying that DEC conceded the interrelationship between the 2 programs. Well, this is just not true. They support this position by references to pages 451 and 639 of the record. At 451, it's part of the response to the summary, and this is what DEC stated. The purpose of this proposal is to review and modify water quality standards. The classification or reclassification program is not the subject of this proposal. At page 369, there's a news article. It simply states, a review of the classification and standards will take place concurrently. That's all it says. It doesn't say there was any connection between them. As a matter of fact, in the DEIS, they commented upon the water reclassification program, and they specifically stated that the public hearings to establish water quality standards are separate and distinct from the reclassification program. So how in God's name can these people say that DEC stated that there was an interrelationship between these 2 proposals? And the second faulty premise is the fact that they show no facts to show that the reclassification will result in any adverse impacts. Again, they're just guessing, assuming that if a party gets reclassified, and you got to consider that they're thinking of over 1,000 streams, and they're saying, well, if one of these streams is upgraded, and if there happens to be a discharger on that stream who has his standards set, possibly he will have higher standards, possibly his discharge will be different, and possibly that discharge is going to hurt the environment. Well, as the Court of Special Term stated, this should be considered in the reclassification proposal itself. As a matter of fact, in the reclassification program for 2 water basins, they've been completed. And in each of those proposals, the department issued a declaration of no significance. And this declaration of no significance, meaning no significant impacts as a result of this, was not challenged in either of these two instances. So clearly, DEC not only complied with seeker, it bent over backwards to comply with seeker. There is nothing in the record to show that the use of tags in any way kept people from making any statements regarding seeker, or did it in any way interfere with the seeker process.
Thank you very much, Mr. Keenan.
You're welcome, Your Honor.
Your Honor, for your honors, on page 46 of our main brief, we have an erroneous reference, which I have to confess to. We referred to a regulation there. We quoted the wrong section. We should have quoted an almost identical section that is referred as Part 617.15E instead of the one we did quote. It's virtually identical, but we did quote the wrong section, and that particular section wasn't in place at the time. Very briefly on environmental impact statement, our objection there was that there was no statement of environmental, adverse environmental impacts, which is hardly a hard look at environmental impacts. It's no look at all. Not a question of whether there should be some additional detail or anything like that. If you don't take any look, it seems to me the department has not met its statutory obligation. Thank you.
Thank you very much, Mr. Banner.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence and appear here tomorrow afternoon at 2 o'clock, at which time this Court now stands adjourned.
Good afternoon.